word timely is important because that's also part of fairness, and the time limits of 14 days, 20 days, 30 days are very precise. It's similar to the CCMA, which require the commissioner to give an arbitration decision within 14 days. So it's very similar to that kind of time period. But it's a timely, written, reasoned decision. Rationality is at the main part of substantive fairness. The driver of the car was negligent because she failed to maintain a safe following distance from the car ahead of her. Conclusion or reason? I hope that's rational. You're trying to establish, you want to reach a conclusion of negligence, and the reason for that is failure to keep a safe following distance. All right, this is a bit of a trivial exercise, but I hope it exists to alert you that conclusions are quite different from reasons. The word because appears, because the employer arrived, or because is often the introduction for reasons. And the next slide's also got a lot of writing, but it is a Supreme Court of Appeal decision about what things, this is actually about tax, but nevertheless it talks about what makes a decision rational. And this was a tax decision, but what is in bold is it's rational when it's tied to the relevant law, findings of facts are there, and look at that phrase, there's a reasoning process involved. It's also, the second paragraph talks about clear and unambiguous language, and the last paragraph simply says length of the report is not crucial. In fact, it goes on to say often going to be at 1 or 2 pages are necessary as long as the reasons are there. How are we going to insulate these disciplinary reports from review? So here is what the grounds of review are in Parja. Now, it's actually, this is almost the first one on the list, and it goes to your points about these rival bodies which might have authority. If you're not authorized to hold disciplinary hearing, that becomes a ground for review. So if you've got these rival structures, you better find out which one trumps the other one, which one has the authority. The only point I want to make is that there's a zone of reasonableness, and as long as the disciplinary committee falls in that zone of reasonableness, they're okay. And just this other case, which is subsequent to the Sadubu case, basically all it asks is that the evidence is there, things are supported by evidence, or the decision is not taken disconnected. Or I'm going to get to, can I just do before tea a quick lecture on evidence 101? Because I do think this is going to become important. Evidentiary material. And there are 2 main considerations. The one is the first decision which a disciplinary committee is going to have to take is this admissible? Because there's lots of evidence which should not be admissible. And the first question they ask is it relevant? You see in these American sitcoms, legal programs like Law and Order, all those kind of things, that they're always jumping on saying irrelevant, you see. And it's one of the main challenges whether irrelevant evidence is going to creep in. From the reports I've read, is that the evidence comes in the form of a document from the laboratories at the University of Free State. And a document is a bit of hearsay evidence. You can't cross-examine a document. And you've got to be aware that you are taking decisions on a bit of hearsay evidence. Now, hearsay is usually, I mean, you can take it out of the range of hearsay evidence by bringing a scientist down and saying, I did the following test in the following way. But be aware that if it's challenged, you're going to have to take it out of the realm. It could be relevant evidence, the report could be relevant, but does it establish the issue in dispute? And then now witness credibility. You might have a witness who's going to give something really important, but as I was learning on the bus, a long bus trip here, your witness could be credible, it could be an expert, but your witness could be another athlete who in fact has also been found, whose credibility has been damaged because they themselves have been found guilty of some kind of substance abuse. So the witness credibility might affect the relevance. It might be relevant evidence, but how strong is it? So the other aspect that comes from admissibility is how desirable is this evidence? And we, in our law of evidence, asks, is it unfairly prejudicial? And you can, for example, actually that's not so important here, let me go to the next point, is things against, is it against public policy? It becomes against public policy where it's improperly obtained evidence, where there's confessions under duress, where there's an unjustifiable limitation of constitutional rights, polygraphs, entrapment. So it might be admissible, but is it desirable if it's been obtained in a way that's against public policy? The other important consideration is the weight you give it. It might be admissible, but how much weight? And here, there are cautionary rules in evidence about maybe for children's evidence, a single person's evidence falls into cautionary rules. How credible is the person? And then, of course, it's a matter of common sense. Now, that's the law of evidence. And in one slide, our students, of course, take a whole semester or 2 semesters to learn all this. But can I just say that I think the way I've read those reports, especially the hearsay evidence of the scientific report from the University of Free State, I think it should be ringing bells about whether it's going to prove your case. This is it's a suggested draft, a suggested template. I'm sure that you're going to improve it. Then the legal framework. Now you can see that this is my attempt to explain to a judge who's going to review it the authority. I hope these statements are correct. The South African Institute of Drugs-Free Sport was established as an independent corporate body in terms of Section 2 of the Act. In terms of Section 11 of the Act, the Institute is obliged to adopt and implement anti-doping rules and policies which conform to the World Anti-Doping Code adopted by the Foundation Board of WADA. SAIDS has adopted the SAIDS anti-doping rules, and this is a decision of a disciplinary committee appointed in terms of Article 8 of those rules, or this is a decision of the Anti-Doping Appeal Board established in terms of Section 17. I'm just suggesting that that is used, or maybe you can refine it, and this might be the place where you might have to talk about delegated authority. I think this should go into every report, every decision, because it'll help the judge if it goes on review. You deliberately in your report put down these procedural issues. You confirm that the person got notice of the hearing, all right, and the date. Then you need to put down whether the person wanted a B sample test. You need to say if they chose to be represented or not.